Good morning. As a previous report, I, Ben Reed, along with my co-counsellor, Usmel Khameh, will be appearing today on behalf of the plaintiff. In this case, the first applicant being Cape Town Dispatch, and the second applicant being the Honor in Kita, in an act between them and the respondent, Zama AI. I shall be speaking first for 11 minutes, addressing the first issue, which is that the respondent's actions do constitute copyright infringement. And I shall then pass over to my co-counsellor to represent the second applicant on our second issue, which is that the digital assets should be transferred to the Honor in Kita. As a please of the court, I shall now proceed with our third vote. She shall be speaking for 7 minutes, I for 11. We shall reserve 2 for rebuttal. My apologies. So, our first issue is that the respondent's actions do constitute copyright infringement. We're going to make this through 3 submissions. The first, that the use of the applicant's data was a cornerstone in the AI's development and creating this technology, a technology that the respondent still profits from. Our second submission is that the question of authorship around the product of AI directly gives accreditation to the author, to the applicant. And our third submission is that international law and academic research are all currently supporting the applicant's claim. We shall proceed to our first submission. Section 2.1 of the Copyright Act says that for a work to be protected by copyright, it must be original. And within the fact set, it describes the works of the first applicant as original content and diverse content. So the fact set clearly indicate that these works are of original character and should be protected under the Copyright Act as such. The defendant may turn to the use of fair dealing as illustrated by section 12, and in particular section 1, 3, and 4, or subsection 1, 3, and 4 of section 4. However, throughout these, accreditation needs to be given to the data that is being taken, which shows that the defendant cannot use the process of fair dealing. The Copyright Act further vests onto the applicant certain rights for their sole usage, namely reproduction of the work in any manner or form, or adaptation of said work. Now, we shall prove throughout the rest of the submission that the AI, through generating its content, does reproduce in any manner or form and adapt the work. A study done by Brunel University London, with conjunction with the World Intellectual Property Organization, noted that to say AI is autonomous is an entirely false premise. As we know, AI is in fact dependent on the developers that are writing the code along with the programmers doing such, along with the human-made content fed into the AI system to create the AI's consciousness.
This is important because if the AI were autonomous, and the court would say it acted on the behalf and behest of the defendant, you could reach the same conclusion.
With regards to saying that
if the AI was autonomous,
yes,
it could still be said to be acting on behalf of the defendant as its agent or employee. And so I don't think you need to label the point about autonomy, because even if we were to find that it was autonomous, there's no evidence suggesting act on its own behest, and so you'd be in the same place. I think rather focus on those other issues that you have been speaking of.
Thank you very much. So, web scrapping clearly violates the rights of the applicant, as the data taken from the applicant was used to train the AI. And only through training the AI with the applicant's data can Zama AI function as it does. It's through reproduction and adaptation of the applicant's data that the output is created. Now, this has been shown in many AI cases. One to name is Getty Images versus Stability AI, where Getty Images photos were taken and used to train Stability AI. When Stability AI then produced artworks, many of them came out with the Getty Image watermark on their productions. This clearly shows the intrinsic link between the output of an AI and the input data put in.
But isn't this then a question of fact in each case? the facts before us aren't that the outputs replicate the your client's works. So the fact that other AIs do so, does that actually assist us? Isn't this simply a question of facts?
Within the question of fact, the fact set leaves the content and specific description of the content that Zama AI produces very vague. So the best approach would be look at what other AI models, notably some of our biggest, OpenAI and Stability AI, are currently producing. So through looking at those cases, we can make the best clear judgment on one at hand, the limited facts we have here. So it's because of this pivotal role that the input data into AI has on the output of AI that we ask the court to recognize that it's through adaptation and reproduction of the applicant's data that the AI can function. To be more specific, we would like to refer to 6A and 6F of the Copyright Act, which is for literary works. In this case, the articles written by the applicant, and then 7A and 7E for artistic works, in this case, the photographs. As a piece of the court, we shall proceed to our second submission.
Yes.
This is that the question of a computer author and the authorship of Zama AI's output needs accreditation to the inputs. Now, in the South African case, Pine v. Bovick, the question of a computer author was discussed. Within this case, the applicant seeks claims for a numbering system produced by a computer, and they succeeded not because they had the rights to the computer program that produced the numbers, but they had the rights to the numbers that was fed into the computer program. This reasoning, using this case, succeeded. The courts, in the case of Pine v. Bovick, understood the importance of input data on the product of computer programs.
So what was the question in Bovick? What was the question what was trying to?
Oh, within
Yes.
Within that case, it was around gaskets for cars. And,
No. The question you just said whether input data was vital. What was it vital to? Which inquiry was it vital to?
within the case mentioned or with the case?
Bovick.
Sorry?
Within the case mentioned, Bovick.
Okay. The question around input data, they were claiming rights to a numbering system produced by a computer, but they didn't have rights to the computer program that had produced the numbering system. They only had rights to the original data that was fed into the system. The computer program was produced by a third party. But their case succeeded as the court recognized the pivotal role of this input data on that.
You're trying to apply that to these facts, no?
Well, in the case at hand, the output data is only possible because of the input data taken from the applicant that has gone through the machine. So
you're claiming the clients of the authors, then if they are.
we claim that our client's work and our client's data is, if I may
You claim that your clients are the authors of anything produced by the generative AI.
we're claiming that the production of the generative AI is dependent on the client's works, yes.
And so therefore, if you're following Clayton, you're claiming ownership, copyright in the outputs of the generative AI, so I understand.
We claim that the outputs of the generative AI infringe on our copyright rather than claiming a right for it.
Computer generated works are available.
Could you rephrase the question, please?
Clayton is about computer generated works. And who then is the author, in section copyright holder author in generated work? You're claiming that as the holders in the copyright and the input data, that is pivotal, a pivotal input, as you put it, into the production of both the generative AI and its subsequent productions.
Yes.
But if we apply Clayton and we accept your argument, the consequence is not that there's any infringement by the defendant. The consequence is that if we accept your argument, that you are the sole holder of the copyright in the software, that is the generative AI, and its products, in which case you shouldn't have sued for infringement. You should have sued that they must sign the copyright to you. It seems to me you've gone with the wrong remedy.
We counsel for the applicant concedes that point. We understand where you're coming from. That was more an analysis to draw a link between the output and input.
Maybe we want to
persuade
make one since
We shall now move on to our third submission, which is that foreign law and academic research are all currently supporting the applicant's claim. A paper written by the World Intellectual Property Organization recently gave some recommendations on what they see as this new frontier of AI to create a more competitive market and increase transparency within the AI market. They recommended that regulations should be put in place so that all AI companies disclose the databases that they use for training. This they believe.
Yeah, that's not terribly relevant. So I'll refer you to some other academic writing. China Pistorius wrote about how in order for the internet to operate, multiple copies of anything that's available on the internet must be made. And so therefore the owner of any copyright who chooses to display it on the internet has therefore licensed, a tacit license, the reproduction of that work. So this presents a problem for them, because now that would mean that the defendant had a tacit license for the scraping that you claim is infringing.
Well, the law is slowly, as I shall quickly show, developing away from it. The recent Artificial Intelligence Act by the. May I request time for an extra minute?
Just 1 minute.
Thank you very much. So law currently at the moment is developing away from that. The current Artificial Intelligence Act that's been adopted by the European Parliament in Article 105 gives a system for companies producing data or producing, in this case, news articles to opt out of web scraping and to opt out of that situation. It's showing a development within international law to recognize.
Which suggests that otherwise it would be in order. Copy that material. They haven't opted out.
Within that, but it's showing a development away from allowing just free roam in data web scraping. I shall now hand over to my co-counsellor to address the second issue.
Good afternoon. My name is Vitumela Fome, appearing on behalf of the second respondent, the Colonel Kiza, regarding the issue of the digital assets being transferred to her. Digital assets, and I'm going to make the following submissions to the court that digital assets form part of property. Digital assets are anything that has value, establishes a digital value rather, establishes ownership and is discoverable. While there are different kinds of digital assets, such as investment portfolios, cryptocurrencies, and the present matter, we are dealing with accounts. That Babu Chiza had in his position through guidance of Ubuntu, which is an application owned by the respondent, Zama AI, where he had purchased several in-game items that cost about 2,000 Rand and ultimately won a Zulu theme sphere that is worth 100,000 Rand. In accordance with the Estate Duty Act, in what constitutes as an estate, it states that a property that the person might have owned at the time of their death. When Babamkhize passed away, what he had in his possession was the account that had the 2,000 Rand and the 100,000 Rand valued Shaka Zulu themed sphere. South African law property. So in order for something to be considered property, it needs to have a relationship. It needs to have a legal relationship between a person and a thing. And while it is easy to determine a person as we can evidence to see one, it's very complex to determine what is a thing. And several scholars, such as Van de Walt, have written about what is legal scholars rather have written how do you determine a thing in the legal aspect. So a thing is really subject to corporate reality, external to a person, independent, subject to judicial control, useful and valuable. While corporate reality is such an important aspect in determining what is a thing in order for it to qualify as property, intangible assets also need to be considered, such as digital assets and this present net of the account. In law of South Africa versus Minister of Transport, the court ruled that property is not just limited to land. It must follow that both corporeal and incorporeal things enjoy protection of the law in accordance with Section 25, subsection 4B of the Constitution. In fact, digital assets can serve as a representation of real life assets and have monetary or economic value in the real world that are valuable to its owners, such as bounties in the present matter, where you see this 2,000 that has been invested into Guardians of Ubuntu. We see that Shaka's redeemed spear worth 100,000 rand. The Estate Duty Act further states that property which is deemed to be property of the deceased includes any property held or registered in the name of the deceased that has some profit. In the present matter, we see as
Which act is that?
the 1955.
You call it the SA?
It's the Estate Duty.
Yes.
We see that Bamukiza had profit in the account that he has with Zama AI. Therefore, the account that Bamukiza in financial investments to Guardians of Ubuntu.
All these statutory references you're making are in relation to especially the special definitions of property. Those special definitions are given for the purposes of the Act. I mean, the fact that a tax act defines property in a certain way, merely for the purposes of extracting a tax, necessarily imply that it's property in the ordinary sense of the word rather than the specially defined sense.
It's important to also note that as much as the SAGT Act might have been referring to like specific property, or however, as I've mentioned, that property is not limited to land, and it does not mean that the people that die every day do not own intangible or incorporeal objects.
Yes, but you, as the plaintiff, have the notice of proof. You're trying to convince us that this particular thing is property. And so it seems to me you have a number of difficulties. You suggested that there were these factors that had to be taken into account. So, for example, that'll exist independently. But that seems to be a problem because it doesn't exist outside the game. The servers, if defendants simply shut their servers down, this asset would completely cease to exist. So why do you think it exists independently? Why is it a thing, and rather than just, some information?
So
No information subject to intellectual property law. So why is this more than information?
because it possesses economic value, because there's money involved in those accounts, which even though the facts of the matter do not disclose this, what if the economic keeper is in need of this money? What if, even though there isn't any information about this in the facts, but we can make the assumption that probably the deceased and the spouse had children, and
I don't think you need to label that. I think focus on convincing the courts that this is property. You pointed out the economic value, but that's not sufficient. It must be something capable of being owned.
It's also because the account and the money and the Zulu share being spared is also tradable and sellable within the market.
Property within the meaning of the game, rather than within the meaning of the real world.
which means then maybe it's not subject to judicial control. If it's in the game, then is that something the court should intervene? Maybe the people running the game should determine.
But however, property is not just limited to land, even the Constitution says so.
Yes,
And
but that doesn't mean it includes this category. The mere fact that it's not limited to land, doesn't mean it's subject to anything.
Saved by the bell.
Alexandra Visser, and I will be appearing for the defendant. I would like to please allocate 9 minutes to discussion of digital ownership, 8 minutes to discussion of the copyright issue with Zama AI, and 3 minutes for the. Today, I would like to discuss the complexities we have in regulating digital forms of property, given that the digital age has presented new issues in this regard. South African law of property has long recognized incorporeal property, as the plaintiff has pointed out. However, it is contended that this does not automatically follow that every single form of conceived incorporeal property would fall under the definition at hand. In this case, Mrs. Mkhize is laying claim to a right of ownership against the video game account and in-game video objects. Before proceeding to our main argument, I would like to please raise a preliminary issue with the court regarding the locus standi of Mrs. Mkhize. I would like to submit that Mrs. Mkhize lacks locus standi in this matter because she has a personal right against the executor of the estate who is in charge of administering this property.
And we understand that facts are not in evidence, so I don't know if you should pursue this any further. Our understanding is that Mr. Mkhize is the executive, so that we should take that point as eliminated and return to the main.
We will proceed to our main arguments. There's been much contention about which area of law regulates the status of digital assets in South Africa. Some scholars have posited that it should stay within the realms of intellectual property rights or within the realms of contract law. We would like to contend that intellectual property rights are not relevant to this particular dispute by demonstration of an example. If I were to own a vinyl record of Taylor Swift, for example, and have ownership of this record, I would not be laying any claim to her intellectual property rights as a musician. And it's the same in the same regard. We are not. Sorry, please have a moment. I can start. Our argument will rest on 2 propositions. And the first is that due to the restrictions as a company that Zama AI is placing on players' accounts and their in-game objects, that they cannot lay claim to ownership and titles in the sense required under South African property law. Our second argument contends that if it were possible for video game players to own in-game objects or their accounts, it would not apply in the present case because of a tacit end-user license agreement between the plaintiff and the defendant.
This is your first proposition based on the premise that ownership always entails a real right, as opposed to personal.
So our first proposition is based on the ownership entitlements that are typically come alongside property. So the entitlement to use and enjoy, the entitlement to dispose of property, and the entitlement to transfer it. We would argue that Zama AI being able to ban their account for inappropriate behavior at any point means they cannot own the account in the sense required because it won't exist perpetually. It's completely subject to our conditions as a game. And similarly, accounts are non-transferable. You sign up with your email. This is not ownership in the sense that we typically conceive of the word. And further, when it comes to in-game objects, if our servers crash as a company, we do not believe that that would make us entitled. I mean, that would make us liable in terms of litigation for the property of every single user, even if this is a temporary server crash. This is part of why we believe there was a tacit end user license agreement between the plaintiff and the defendant, particularly because the plaintiff's deceased husband was an avid gamer. He would be aware that this is standard industry practice to have an end user license agreement.
So if it's not an instance, and if the plaintiff's husband had left his password and username available, and his wife had accessed his account and sold the sphere, you would have no remedies on your current argument. You would have no remedy. Is that correct? Because there's no asset. You can't say, well, that sphere has to come back. It shouldn't have been transferred because it's not property. So is that, or is there a basis on which you could that would be allowed?
Well, we would argue that in terms of the tacit end user license agreement, that the account forms part of a non-transferable license to use. And so, in fact, the first place, she would not have access to that account because he has signed up in an individual capacity to access this account. So that situation should not unfold.
De facto, it could.
It could, but then we would have a remedy in that she had no right to access the account in the beginning.
Could you get the sphere back from that other party who paid good money? Would your remedy be against her?
I believe the executor of Mr. Mkhize's estate, if it were to constitute property, would then have a claim of unjustified enrichment because they had transferred it out. To continue with the argument that there was a tacit agreement, we would refer the court to the case of Joel Melamed regarding tacit agreements, where the court imported the idea from a tacit term in a contract that one of the primary considerations should be the business efficacy of said term to the contract, and into the idea of tacit agreement and business efficacy. And we would say that no video game company could have a sustainable business model if, like I said, our servers crash and every single player.
Well, when you're dealing with tacit terms, you've got to resist following the course of imputing a term just because it would have been wise or convenient to have it, not be necessary.
Yes. So on that basis, we would argue that it is absolutely necessary. And even in applying when it comes to a tacit the officious bystander test, any person on the street would know that every time they sign up to Facebook, they have to scroll through a long terms and conditions. They know that the basis on which we contract with digital platforms is one in which we are agreeing to their terms of service, because again, they can ban you at any moment. They can delete your account, they can suspend it, and this is simply standard industry practice, we would argue. And then we would further like to submit an argument to consider policy considerations, and that whilst the facts at hand are very particular, should we recognize in-game video assets and video game accounts, that there are broader policy considerations, as this has been flagged as a potential hotspot for money laundering or fraudulent activity. And so without the necessary regulatory infrastructure to accommodate that, any blanket recognition now could potentially facilitate this happening. If it pleases the court, we would like to move on to the issue of copyright. The defendant, Zama AI, vehemently denies any liability for copyright infringement, and this lack of liability will be shown by invoking the fair dealing defense. Thereafter, policy considerations will be discussed, and in the event the court does not find that the fair dealing and defense is adequate, We would contend that perhaps the current copyright regime is unable to cater to circumstances as novel as the one before us. Fair dealing under section 12(1), section 12, subsection 1 of the Copyright Act allows for an exception to copyright infringement where the infringing copy was created for research purposes. We would contend that generative AI is a rapidly developing branch of computer science, with its presence being notable in many research-related fields, including legal technology to medical technology. Zama AI's contributions to this place South Africa as a viable location to continue these developments. We specifically would like to address the claim by our learned colleague that that prevailing scholarship weighs against our client. And we do not believe this to be true, and would cite Associate Professor Schoenberger's article referring to the need for developing countries to have the regulatory infrastructure to keep up in a sense. Further, with regards to the legitimate interests of the copyright holder, we would submit that as a news source, the legitimate interest of the plaintiff would consist of maintaining a loyal readership base based on current events specifically, and proceeds from various sources of advertising. We would contend that Zama AI is not infringing on their legitimate interest because it's reaching a different target audience.
I want to contextualize this in interesting. I understand you correctly. You're not contesting that the works are original. Is that correct?
Yes.
And you're not contesting that there was copying. Is that correct?
We are contesting that there was copying in the sense that we
You're
believe,
saying the copy is not infringing.
yes,
And then you're referring to fair dealing. And this legitimate interests must be factored into whether the dealing is fair. Is that correct? So what's the overall test for fair dealing that we should be using with reference to South African law?
so the test for fair dealing has been referred to in MoneyWeb and Laughter Productions as a value judgment by the court, and one which weighs and balances the interests of the different parties at hand. In this case, it would be Zama AI, the plaintiff, as a newspaper source, and also public interest, which we would argue the public has a vested interest in AI and its capabilities, and the extent to which.
My question. We know that AI uses up massive ecological resources, water, energy. So is it in the public's interest for AI to be advanced, or rather, is there, since there's a danger of climate change, isn't it the court's duty to regard AI as not a benefit? We're going to bring the public interest into it. Then there are arguments against that. AI also displaces workers by replacing them. So it seems that the public interest may not be as strong as suited.
Well, it depends how we factor in weighting to the different public interests. For example, when it comes to legal technology, we have a grave issue with access to justice, and AI in the legal space has been considered as one avenue to bolster.
Isn't this whole issue of public interest a policy question? We should be careful of including it, isn't it? Really a matter for the executive and the legislature between them to decide that the public interest is best served in this area.
I would argue that being given the space of a value judgment allows the court to account for public interest, if not engaging.
Well, that's inter partes, isn't it? Rather than in a broad public sphere. The balancing of interests, the like referred to the cases you mentioned comes into play.
Yes. I would argue though that this would not be the first time the court has been in a position where it's had to regard the greater public interest, and even in considering any cases regarding the Bill of Rights would have to make considerable value judgments on public interest matters.
Well, difficult to do that without a broad canvas of evidence. One doesn't have in this case.
Yes, yes, we can see that. Yes, okay. We would also like to address a point that the plaintiff made about the degree to which this reproduction is happening, and they claim that our output is infringing on their copyright interests, when in fact there is no evidence to suggest that our output has met the substantial art test for copying. As seen in the Money Web case, where particular paragraphs were copied even verbatim within the news article, this did not meet the substantial part test. And again, even if AI, our Zama AI is copying a sentence or two from, there is no precedent to suggest that this would be enough to satisfy copyright infringement.
Just before we move on to rebuttal.
As it pleases the court, we shall now proceed with our 2 minutes rebuttal. But first, like to contest the use of fair dealing under section 12.1, which is for the use of research. This data taken by the applicant was not for research purposes. It was to build a profiteering AI machine that they still currently profit off of.
Does section 12.1 say non-commercial research? It says research.
For the purposes of research or private study by, yes, it does not say for commercial research. We shall concede to that point. Another rebuttal we would like to make is she mentions our learned counsellor mentions the point of keeping up infrastructure within South Africa to boost the economy and help generate AI. But that doesn't mean it needs to be done unethically. And within this case, we argue that the current way that it is being done within South Africa with pure web scrapping and no accreditation given to the sources, like that is now the norm and legal and required within the European Union, should be changed. And that's to suggest that the way it currently is should continue to develop is wrong. Then with regards to the second issue around digital assets being transferred, a large part of the respondent's case relied on the fact that, well, if the game disappeared, so do your assets. But in the modern world of technology and digital assets, we have systems such as tokenism and blockchain, where these systems can exist externally from, in this case, the video game. Which would be
Not tokenized. There's no evidence of that.
The facts leave that open-ended, that it's of course discretion. And we
It's not for the court's discretion, facts are facts and they're going to be proved.
They're not there.
say it like that.
Just insofar as my learned colleague mentioned accreditation, we would argue that that is not relevant in this case. As has been discussed, we are web scraping from millions and millions of sources. To accredit to millions and millions of sources would not only be impractical, but unreasonable, because again, only small parts are being used. And so having to accredit for every second sentence where not even the whole or part of the sentence might be from.
So you're saying that if you engage in, if you infringe one company's copyright, that's infringement. But if you do it to thousands, then it's okay.
No,
Is that the argument?
I haven't conceded that we've infringed at all. What I'm saying is that with regards specifically to his allegation that we should be accrediting Cape Town Dispatch in our output, that this would not make sense because of the way our AI learns. It's only going off of the next most probable word. It's not even verbatim copying them. And so to accredit something that isn't even verbatim copying them at this point and has not been shown to be a substantial part would not make sense in this particular set of facts.
Thank you, President. Are we done?
Yes, we are.
We can close the session.
Yes, thank you very much.
Thank you.
We close the session. The court will consider it.
So thank you so much, everyone who give our judges time of museum scores. Now we can rate, network, and yeah, wait for the results.